Hi, everyone. Welcome to our Facebook Live broadcast. I'm Steve Altition, Director of Client Partnerships here at Lander Home Family Law. And today I'm here with attorney Triston Dallas, our estate planning specialist, to talk about why this time of year is a perfect time to review your estate plan. How you doing, Triston?
I'm doing well. Thanks for having me as always.
Well, thanks for coming. So before we start in, let's talk a little bit about estate plans in general. I know there's a common misconception that estate planning is only for those more senior members of our society, and also just for people with major assets. But that really isn't true, is it?
No. Estate planning is for everyone. As you know, we've mentioned in a previous video webinar, everybody has an estate, whether it's super small, super big, if it's everything you own, excuse me, everything you own is contained within a small town or it's international. There are definitely things that and steps that every individual can take in order to manage their estate and to pass their estate on to their loved ones.
So, why is it a good idea, let's say at the end of a year, the beginning of a new year, to kind of sit back and make an assessment of your estate plan?
Yeah, I mean, a lot of life happens in a year. A lot of things can change, as we'll go through today. We'll talk about some major high level points. But 2020 specifically has just been an interesting year. A lot of things has happened for everyone, from being quarantined and no work happening for virtually the entire population for, several weeks on end, to businesses going under and people losing retirement, their nest egg, and their homes, and all kinds of things have happened. And just because those negative things have happened, or even positive things may have happened, it doesn't mean that you want to overlook, things like your estate plan, just because a lot of what has happened this year can affect the plan and make sure that it's still effective. It still does what you want. And depending on how it's structured, your estate plan may not necessarily have the funding or the assets you once thought it did in order to pass on to your loved ones. And on top of that, I mean, health-wise, anything can happen within any time, unfortunately. And with the pandemic, if you don't have an estate plan, this is the time that you want to take to speak with an attorney, and to take those steps to get one done, just because you're going to want to make sure your family or loved ones are taken care of, and don't just leave things into the hands of the state, just in case, the worst was to happen.
Well, that makes total sense. And like you said, especially this year, it's not just a normal looking back over your year, but it's also really a looking forward.
Yep,
And it seems like it's really important these days to concentrate not just on the past, but looking forward.
absolutely.
So let's take a look at some of these life events that can affect an estate plan. But
Yep.
before we do that specifically, can you just touch on some of the main documents that are part of your estate plan, um, how they can be affected by life events as we move forward?
Yeah, yeah. I mean, the first thing anybody ever thinks about is a will, when it comes to an estate plan, and that's a big portion of probably the estate plan for most people. But it isn't the end all be all. It isn't the only document, or thing to analyze. In any estate plan, there's also tax planning and estate tax planning, gift tax planning. And so there are a myriad of documents that could come into play with those. And we won't get into the minutia of all of that, and get lost in the weeds, but just kind of understand that there are a lot of tax documents, that could come into play here. Um, but from the other perspective, and not just thinking about tax, I mean, there are trusts. That's the other big thing that people think about when they think about estate plan or estate planning. And there are different types of trusts, from irrevocable to revocable and charitable remainder and all kinds of trusts, special needs, et cetera, et cetera. But even beyond that, and those documents only really speak about, potentially just asset, distribution upon death. Um, in connection with the tax portion of things. But other documents that are important to have or important to consider are your power of attorney, how deciding how things are done when something has happened to you but you haven't passed away, and who's going to step in and help with those things. Healthcare or advance directive, who's going to make medical decisions for you potentially if you can't make them for yourself. Understanding where your retirement is. And one that we've kind of thrown out there a couple of times that people overlook probably most often, that can be a very big vehicle, is life insurance. And just understanding how that can play a part into your estate plan, depending on how it's going to be structured.
That makes complete sense. It kind of made me think that as we now start to look at some of the life events and the revisions, we aren't just thinking about the beneficiaries that
Yep.
that may change, but also the people that are what we call the fiduciaries, the
Yep.
executors, the trustees.
Yep.
That can all be changed. So,
Yep.
having said that, let's start with one of the major options that some people, or events that some people have and can vastly affect their lives, is getting married or getting divorced or getting remarried.
Yeah. I mean, there's so much that kind of goes into that. And, we did recently do a webinar specifically kind of on this topic. We did more of a deep dive, so definitely check that out. But those, all those things, divorce, marriage, remarriage, all have a big implication to your estate plan. You're bringing a new life, multiple new lives into your world of assets. And you may want to do things differently, depending on, which of those things that have happened to you during the year. Specifically with marriage, as we mentioned before, you can't completely disinherit a spouse, and not to say that anybody would want to, but you do need to understand that, as if you've already created an estate plan prior to marriage, you do need to understand that, without some type of like prenup or anything like that, that they're going to have interest into your estate in the event of your passing. So you do want to take that in consideration and figure out, how does this marriage, how do I create my estate plan in a way that all the things I previously wanted can still be accomplished with also taking care of my new spouse, or children, what have you. And when you have, blended families and you're, worrying about that issue, that could be a thing as well, and a big point to consider and to think about. And with divorce, as we mentioned before, you if you're getting divorced, you're not going to leave your estate to your ex-spouse. And there are things in place and policies in place to avoid that, but they aren't ironclad. And so you want to make sure that you're removing all doubt in regards to your estate plan, and your beneficiary documents, whether it's like retirement or life insurance, to make sure that your ex-spouse isn't, the one that's listed as the beneficiary. So there's a lot of things that you want to consider, and there's a lot of pitfalls that somebody can, easily walk into without really thinking about.
And I guess it's not just things that happen to us.
Yep.
That said, what if your children getting married, or your children adopting someone, or them remarrying?
Yep. Yeah. There's a term within the Oregon laws called right of representation. And so the best way to explain it is, if you have two children, and you draft your estate plan, or you plan on giving your assets to your children equally with right of representation, it essentially bifurcates your estate and then creates a interest for their entire line. So if both of your children have children and something happens to either of them, their line still has interest into the entire portion that their father or mother was supposed to have. So if it's 50% and your child passes away, but your grandchildren of that child are still alive, they would inherit that 50%. So it's important to understand that concept, even if it doesn't mean you'll have to take a specific action right this second. But on the flip side of that is, if you're setting up things like a college fund or marriage fund or anything like that, or even an early retirement fund. I've seen clients do that as well. They want to make sure that their grandchildren are taken care of from very long down the line. You want to make sure that if you're doing it for one grandchild and you want to make sure all the other ones get it, you do have to take have a concerted effort, take some specific steps to make sure that happens, and make sure your plan coincides with the plan that you have in your head about distributing your assets.
The birth, the adoption, the new life of a new family member, obviously big reason to look at your will. A lot of times people maybe not think about, though, what about the death of someone in your family, your spouse, a child, maybe even a grandchild?
Yeah. I mean, all those things are important to consider. And going back to the adoption point, that's probably one of the biggest pitfalls when it comes to children or grandchildren. Just because sometimes your estate plan may not have been drafted in a way to consider them as a true heir of your estate. And if you want them to be, or don't want them to be, you do need to make that clear. So you want to make sure you're looking into and making sure that your wishes are followed in that way as well. In regards to death, it's kind of the opposite side of the same coin, as we just mentioned. If one of your children passes away and only one of them has a child, it could affect how the division of your estate is adjudicated or distributed. And then, of course, with a passing spouse, blended families, those things are going to have a big impact on exactly how your estate is going to be administered at your death. But also with things like if you have a passing spouse, now, potentially you're inheriting more estate, again, depending on how the plan is really put together, but you might have tax implications that you have to now reconsider. If they had, interest into assets that were separate from yours, or if there was kind of prenup and those types of things, you do want to, again, reevaluate where things are, because you don't want to overlook things. It's potentially, something like a retirement. If one spouse dies and the other spouse inherits that retirement, that easily could push somebody over the tax limit, or the tax threshold in Oregon, which is only $1 million, state tax, that is. So you want to understand kind of where your financials are and where your assets are, and again, how they would be distributed in the event of your passing.
Let's talk a little bit about your becoming ill or disabled, or your spouse becoming ill or disabled. While we talked a lot about beneficiary changes that can come, this could also lead to changes in the way your estate is managed and who might manage them.
Yeah. Very good point. And very good question that we all should consider. I mean, the first one with your own illness, in the event of something like that, where you have a severe illness where you can no longer handle your own assets, the best thing you do is have something in place to make sure that, your family members or those that you trust can step in with ease to take care of you, and make sure that your assets are managed well. You don't want to make that process difficult for them, because it's only going to make things difficult for you when you're back and healthy and trying to pick up the pieces there. Having a power of attorney is a big thing that could help, and you get to specifically designate what things that person can and cannot do. So it's just something that it's a lot of autonomy that you have, obviously, with your own assets, but it's an easy step that can be taken, and that will solve a very big problem. And that's only just one specific example there. With a spouse, it's kind of similar, just on the other side, making sure you can step in. And even though you would be married, it isn't guaranteed that what your spouse owns or has if it isn't a joint asset, that you're just going to be able to step in and take action. And so, again, that you and your spouse are married, and you would think that you guys are quote unquote one and it wouldn't be an issue, but it can be. And third parties are going to do, especially like banking institutions, they're going to be very conservative about, what they're going to allow somebody to do without a power of attorney, or something like that listed on the record for them. And for disabilities for children, whether they be minors or adults, you start running into special needs planning and special needs trust and those types of things, as your estate plan may want to leave money for them in order to take care of them. But if you're not doing it in a particular way, and that person is receiving some type of state aid or state finances or anything like that, you can't end up affecting or even kicking them off that aid without the proper planning. So you do want to take all these into consideration. And like I said, a lot of things happen in a year, and a lot of us have family members or friends that have dealt with a lot of medical issues, especially with COVID. It's easily that we could have fallen, or somebody that we know could have fallen kind of under hard times dealing with a disability or some of a medical issue.
So what if one of your children or grandchildren reach the age of majority? They turn 21 or 25 or 18, whatever may click something in your estate plan.
Yeah. And again, this one's a little bit more focused, as depending on how your plan is created, and depending on specifically how you want things to be distributed. If you have like a trust that has a graduated distribution schedule where, a grandchild or a child is not going to receive something from them or from you until they reach 18 or anything like that, which then has an effect on the assets that you have. Or if you're going to make some type of gift or do any gifting because they're going into college or anything like that, you do want to reevaluate where your estate plan is, where your tax planning is. There is a gift tax that could creep up depending on the amount and level of the gift you make. So you want to consider all of those things as you're making those gifts or even considering them. And again, just how that affects your plan overall and down the line. And that's probably one of the bigger things. The other thing is, when you have children or grandchildren that become age of majority, they can take a bigger role in your estate plan if you want them to. Sometimes a married couple may only have one child, and they want this person to step in as backup of their entire, estate plan for different roles that they couldn't do before. And so being able to reevaluate your plan, or even bringing them in so they can understand where your plan is something that is probably very valuable to an individual.
Well, that makes sense. Kind of makes me just think back on ours. We would not have named our 2 and 5-year-old a alternate executor,
Mm-hmm.
but as they became adults, that can happen.
Yep, absolutely.
So looking now to assets kind of as an issue, and not, I think this also can be not just from the sort of general beneficiary, the general distribution, but even like specific asset distribution.
Yep.
What happens if you have sizable changes in the value of the asset you own, or especially maybe one particular asset goes up tremendously?
Yeah. I mean, the first thing honestly that comes to mind is just, what's the tax implications there now and down the line. Again, 2020 being what it is, people have lost businesses, people have lost family members, and maybe inherited something that could be of a sizable amount. And now you have to deal with that. You have to analyze that. And again, Oregon being what it is, and the estate tax threshold being only 1 million, you incur a sizable amount. Even with a small home or a small retirement, you can be pushed over that. So you want to understand how that affects you, how it affects your family, And additionally, what steps you can take in order to limit or even mitigate the estate tax as it is, even though you may be reaching or over that threshold. Um, and those are things that you may not necessarily just be able to find out, or most of the stuff you're not really just going to be able to find out just by going to the internet. So you want to, speak with an attorney or speak with an accountant or both, and understand, what the tax implications there. And then, depending on the way your plan is drafted and how you're distributing assets, if you're giving one asset to one individual and another asset to another individual, but you wanted things to be a little bit equal, if one, balloons, then, it creates that disparity. So you want to understand how that affects that as well.
Moving on to another sort of particular instance, but so what happens if you sell or buy, but I'm thinking even more sell, your principal residence, or you buy or sell a business?
Yeah.
Are there, I was
Yeah.
going to say, are there particular things about that you should be aware?
Yeah. For sure. Selling a residence has multiple levels of kind of tax implications. Your principal residence, usually within some type of plan, there's a specific clause or reference to your principal, residence. And so if that changes, you probably could, depending on how your plan is drafted, could get away with not having to take specific action right away. But you do want to make sure that it's clear as to what assets you do own as they're in your estate plan, whether that is just listed in your will, and how it's going to be distributed, or if it's listed in a trust. Understanding, okay, now if I sold my principal place of residence, it's no longer in my trust, so I need to make sure it's clear that it's been removed. But at the same time, you're probably purchasing a new home, and you're going to need to place that home into the trust and get that funded there. So, with trust is probably the bigger worry, just because you want to make sure you're using that vehicle. And as you get assets or remove assets, you do need to make sure it's clear as to the funding of the trust, or it may be not in the trust at the time of your passing, and therefore not receive the same benefits you're hoping it to have as being a trust asset. Sale of a business, there's a lot of things there because a lot of moving parts, especially if you have a partner, or you got shareholders or anything like that. Just because there's going to be specific succession planning that's going to be of note in the business itself, and may have its own rules that you need to make sure that you are following. So there isn't any confusion or missteps there, and that your portion can be, that interest can be passed on to your heirs properly. But again, sale of a business, as we mentioned in kind of the previous note, you're going to incur probably a big interest into something, whether it's just, again, buying a new home, or you're going to get a payout for, selling your business. You're going to then need to consider how that affects the short term and the long term in terms of taxes in your estate plan.
Well, I think you just said something that was really important, and a lot of people don't get, especially when you're talking about trust, is that just saying opening a trust and giving, putting money in it or putting something in it and giving it to your kids when you die, you may sell that thing or buy a new thing, and they don't automatically go into that trust, do they?
Nope. You do have to take action to make sure it's when you get a new asset, purchase a new asset, acquire a new asset in some way. If you want it to be in the trust, you have to take specific actions to put it into the trust. It's not an automatic thing.
Yeah. So what about acquiring property in another state? Let's say I decided to buy a beach house in California, or property somewhere in another state.
Yeah. The issues you run into is not fully contemplating how that may affect, or how the administration of the estate will go. Having, you know, real property in another state may trigger probate in that state as well, depending on, you know, again, how your plan is set up. You know, with trust, you might be able to avoid some of that. But you just need to understand how the administration of your estate is gonna go, and the steps that your fiduciary may need to take, and obviously make them aware that this is a thing, for the fiduciaries that would be stepping in. Obviously, if it's a spouse, they're going to know about it, but you know, the backups and all that, you know, are probably good for them to know what is in your estate.
Yeah.
So understanding those things is really the kind of the bigger, big picture things, as opposed to more of a micro kind of smaller, immediate issues.
Right. So what if I moved? What if I've just moved into Oregon from Florida or moved to another state from here?
Yeah. Yeah. It doesn't mean that the whatever you've created or put together, is invalidated. It just means, that potentially there are going to be new laws that are going to apply. So you want to understand how that works. You know, for example, just going back to acquiring property in another state, the same situation happens if you acquire property, let's say Oregon, and you acquire a home and then you move to, let's say, California, but you didn't sell the property here in Oregon. Essentially, that's just a property in another state. So you end up having to deal with the same questions, previously, that we previously mentioned in the previous point. Um, so moving just means that different laws may apply, and you want to understand how the trust laws and the probate laws, affect your, estate planning and a distribution at the end of the day. And then tax planning, every state is going to have different rules on the estate tax threshold. And so just going to Washington, I think they're either just under 3 million or just over 2 million, as far as the threshold. So that changes the evaluation a little bit as well, as you have less of a worry about kind of hitting that number. If you're only at 800,000 and you're, you know, in your 60s and 70s, a little bit less worry there because of the higher threshold. But you do want to make sure you understand, kind of the personal property versus real property. You know, personal property is going to have a little bit less of an evaluation or worry, than things like real property and how they're, administered and dealt with in your plan.
So what about the people that are helping run our state on that point? You know, we've raised our kids, we've given them everything, and then the ingrates move off to another state.
Yeah.
Can they still
Yeah.
be the personal representative?
Yeah. The person you picked to act in any role in your estate plan can, for the most part, be, anywhere. I'll say now, just anywhere in the U.S. When you have a trust and you start having, let's say, a trustee that's going to be someone in a different country, you run into some other issues. But for the most part, that person can be anywhere, but they need to understand that where the estate will be administered, let's say it's probate, and you know, if their person is in Oregon, but their son or excuse me, their son or daughter is in New York or Pennsylvania or something like that, that they will have to deal with Oregon in order to administer and probate the estate. Just making sure they understand, how their role is actually going to work if they're not actually in the state where you resided, where your assets are. And especially if this is somebody you really want to be a part of your plan, and they're living internationally, you definitely want to make sure you're talking to an attorney to make sure you're not running into issues there.
Yeah. So kind of following the line of our kids growing older and moving away, what about us, hitting retirement age? Is
Yeah,
that something we need to consider?
yeah. I mean, your income changes, right? Your first, you know, before then, you're earning an income and saving and putting things in a retirement. Now retirement is growing. And then you hit a peak and you retire, and now all you're doing is taking that retirement, slowly starting to come down, or drastically kind of starting to come down, depending on what you do. And so what you're going to be leaving or be able to provide to your beneficiaries or your heirs is going to change on a regular basis, because you're starting to spend those, saved assets and those saved funds. But even kind of beyond that is it's going to change potentially where your tax implications are going to be. If you're already kind of teetering at that million dollar mark, and now you're in retirement, you're going to be spending that stuff down. It's less likely you're going to have to deal with it. You do want to plan for it and have a contingency, as anything can happen, but it may be less of a worry if you're trying to make sure you're under that threshold and worried about early gifting or anything like that. So it is something to consider, and is something for you to understand. Especially with things like Social Security benefits and all of those as well. You just want to make sure how you understand how it's really affecting the bottom line in terms of taxes and distribution.
I also imagine that if I receive an inheritance, if someone passes away and suddenly I get a lot of stuff, that certainly might have an effect.
Yeah, it does. And it just goes back to like selling an asset or anything, or incurring, an asset that increases in value. Your tax bracket, your tax liability, it could change. And now you have additional assets that you can pass on to your heirs in some way, potentially, depending on how you're receiving the asset from, a mom or dad or uncle or anything like that. So if it's something that you do have, the right to control, the autonomy to utilize the asset as you see fit, now you have something else that you need to consider. But like I said, when it comes to Oregon, it's first and foremost is going to be understanding how it affects that estate tax planning. And I did want to mention, going back to the previous point, is when you're in retirement, you're spending down your retirement and you're using Social Security. If you're hoping to leave some of that retirement to children, but now you're using most of it because you're in retirement and that's your source of income, then you kind of fall into, okay, well, can life insurance or anything like that cover, some type of funds that you want to leave to, to your heirs, if that's something you want to do. But understanding your finances and what you have and don't have is going to be important in order to accomplish those type of goals.
These are all great, or I think important life events, and there's probably a lot more. The way you're giving us this knowledge it's kind of things that touch things you own, or things that touch people that will be involved in your estate. Any of those could have an issue.
Yep.
And so not necessarily life events, I imagine there are other just sort of changes that can occur that are hallmarks or flags to make you think about your estate plan.
Yeah, for sure. The first thing that comes to mind is just change in laws, change in procedures. The federal, with the change in presidential administration coming up, the change in like federal estate tax may go down as far as the threshold. Right now it's pretty hefty amount, at 12 plus million mark. It could go back down to as low as, 5-6 million as it was previously once was. And so understanding that is probably, that point is probably the first thing that will come to mind. And then not necessarily changes in your life, but just changing things that are around you. If you find there's a charity that you're now very, close to or want to support, changes in how distributions of retirement is, could come up. You just look a year ago with the Secure Act and how that changed how individuals can distribute their retirement and the required minimum distributions, and even that connected to things like special needs planning. And there's things that happen outside of your control that you may not necessarily know of, and may not necessarily even be connected in a way outside of your attorney to understand that that's an issue. And so just even getting the time to speak with the attorney, or just, taking the time on your own to figure out, okay, what things are out there that may affect me, that didn't come from me are important. And then just social impact, again, COVID and everything that we've dealt with over the year, changes your perspective, changes the way that the world is operating. And that itself is probably something that you should think to yourself, okay, maybe I need to reevaluate everything. It's going to be even bigger than just the estate planning piece, but just evaluating where everything is. And this kind of falls into children. Some people will call them children, but pets is another thing you want to make sure. People do leave trust for pets. People do have specific clauses or terms in like power of attorney when it comes to their pets, and want to make sure that they're taken care of as well. So those are some things. Obviously, it's not an exhaustive list, but a lot of things can change in a year, as I mentioned earlier. And when those things do change, you want to make sure that you're keeping on top of how that affects your bottom line, how that affects your estate plan, how that affects your beneficiaries when you're no longer here, or how that affects you when you can't make decisions for yourself, but you need somebody else to step in and do so.
I got to say, we've gone over our 30 minutes, and we could probably go a lot longer, but unfortunately it's time to wrap up. And Triston, thank you so much for joining us today.
Thank you for having me.
It's wonderful to have you here. And, you gave us important tips, and not only just to, help us know what planning tips, to use, but also just help us remember that estate planning is for everybody.
Yep.
And so, with that, I also want to thank everyone who tuned in today to our Facebook Live broadcast. And if anyone has any questions, again, please feel free to send an email or post them here on Facebook, or you can send me an email, steve@landerhomelaw.com, and we can set you up. Triston had mentioned about having a consultation, and Triston definitely does that. And so any questions, give me a email, post it, and we'll make sure we get you set up. And with that, everyone, until next time, stay safe, have a great day, and see you next time. Thank you.
Thank you.